welcome to everybody on the webinar. We've got the largest number of registrants I think we've ever had, which obviously highlights how topical and timely how to use legitimate interests legitimately is. And we're delighted at Bristows to be hosting this for the Data Protection Network. And I'm particularly delighted that we've got an international approach to legitimate interests, because we're not just going to look at it from Europe and the GDPR, but we've also got a guest presenter, Marty Abrams, who's going to talk about the work that's been going on from the US and Canada side of this, and I'll talk a bit more about that in a moment, as indeed will Marty. I wanted just briefly to introduce speakers for today. I think many of you know myself, and I'm mostly going to be not speaking but moderating. But I'm joined by Rosemary Smith, who is co-founder of the Data Protection Network and of the compliance company Opt4. And we've been working in the Data Protection Network on a legitimate interests guidance, as you know, which many of you have downloaded. And of course, we'll be happy to supply links to those that have not yet downloaded the guidance. And we're particularly excited that we continue to get support from the Information Commissioner on what we are doing. And you can see on this slide there Rosemary's background. From a business point of view, we're delighted to have Emma Buckner, Data Protection Officer of Yoti, joining us. Emma has a long and distinguished career in data protection, and it is extremely useful that she has in the past been involved significantly on the regulatory side through her position within the Information Commissioner's Office, and of course has been in a number of in-house positions and was very much part of the drafting process for our guidance. And then, as I say, we have got Marty Abrams, Executive Director of the IAF, which Marty in a few minutes is going to tell us more about. But it was quite interesting that there we were in the Data Protection Network, feeling we were something like the inventor of the first light bulb, only to discover that Marty had invented a legitimate interests approach through the IAF at particularly the same time, although taking a slightly different approach to the outcome or the end result, in that what a lot of the work that the IAF is doing is around data privacy impact assessment as a process in the round, and particularly, as Marty will tell you, in terms of ethics and big data and analytics, whereas what we were doing in the Data Protection Network was focusing purely on legitimate interests as one of the lawful grounds for processing, and trying to produce a practical way of helping businesses of all sizes and sectors to find an alternative to consent. But I wanted to, before I hand over to Rosemary, say this is not about finding the ultimate get-out clause that avoids you using consent when consent is the right method. And that's something that we'll talk about a bit later on. In terms of the admin for today, we are very welcome in terms of you sending in questions as we go through, although you will see that on the next slide we have listed a whole host of questions that people have very kindly sent in advance. We've had hundreds, literally hundreds and hundreds of questions, many of which are similar, so we've distilled them into some which I will put to our expert panel, and we can try and help you by the end of this webinar have formed an approach and a sense of direction as to where you might go or can go with legitimate interests. We will be recording the webinar, It will be available together with the PowerPoint slides for download a few days after we have finished, and we anticipate finishing on the hour or just thereafter. So I want to just ask you, Rosemary, if you could tell us for a few minutes how we started on the guidance and where we are and where we're going.
Thank you very much, Robert. Yes, happy to do that. I suppose the first question is, why did we do it? And that really came out of discussions within the data protection network, our wider community online, and also around the governance board table about exactly what we thought legitimate interest was going to cover, about the concerns that we were hearing from the marketplace about how challenging consent was going to be, even more challenging without lots of guidance at that stage. And we knew that as the GDPR text was going through the legislative process, that as organisations had lobbied and if you like complained about this very high bar for consent, the regulators were often coming back and saying, no, legitimate interest would be more appropriate. You mustn't forget you've always got the possibility of using legitimate interests, balancing your interests with those of the individual. And our regulator, the Information Commissioner's Office, has continued to assert that in what they've been saying. So whilst we haven't got guidance from the ICO, we very much wanted to establish, if you like, some ground rules and put forward a considered industry position. So that's why we did it. How we did it? Well, we were very lucky to be able to gather a very erudite panel consisting of data protection officers, legal counsel from a wide range of top brands. One of the things we wanted to be clear on is that we wanted to look at legitimate interests in the round, not just for specific purposes, and that we wanted to look at its potential use in a whole range of different sectors. So we had a lot of different sectors represented around that table, including media, travel, software, not-for-profit. So a very good spread. And they worked very hard, our drafting panel, and I thank them very much for the work that they did. We were also very, very pleased early on to get the support of both the Direct Marketing Association, the Incorporated Society of British Advertisers, and even latterly the Institute of Practitioners in Advertising. So trade associations coming on board and really supporting the initiative and saying that they would bring their members' views into play as well, which was great. We made the decision very early on that we wanted to engage with the Information Commissioner's Office because we felt that this guidance needed to go past them, and we were very lucky that we got a welcome from them. They very much welcomed the initiative and gave us some very useful feedback on the text, and the text that we have published has indeed incorporated their requirements, their amendments. So that's been great. In terms of where next, we've had over 3,000 downloads of the guidance, and we're delighted that so many people have found it useful. We've had some very helpful feedback from users. I know that a number of organisations have already started to use the legitimate interests assessment template actively in doing their balancing tests. So that's, I think, proving useful. So we do intend to produce version 2.0. That will be coming in the next couple of months. We want to incorporate comments we've had. We want to take more input, and also I think it would be helpful to include even more examples of circumstances in which legitimate interests may apply subject to that balancing test. So my message, I suppose, finally is just to say that we would welcome input into that next round of drafting, and anybody who would like to help us out, please do get in touch.
And indeed, when people registered, one of the questions we asked is, would you like to participate? And we actually had a lot of people saying very much so, and some saying, let me think about it and let's hear the webinar first, etc. And then literally last week I had a technology company where the chief compliance officer said, I really like what you've been doing, I just wish we had more examples for the technology sector. So there is no doubt that we hadn't done as much as we could do, but as Rosemary says, we're looking for as much input as possible. And again, talking to Elizabeth Denham within the last few days, again, she's reiterated just how valuable this industry approach is. And I think it's just a reminder that she can't do all the guidance, and this is a good example of where industry is trying to self-help.
Yeah.
Also, we know that Helen Dixon and her team at the Irish Commission have also looked at this, and indeed so have the Singapore Commission, on the basis they also can see the value as a regulator of doing more with a legitimate interest if it is managed in an appropriate fashion. Talking about managing ethically and so on the use of PII and personal data, I'm going to now ask Marty Abrams, Executive Director of the Internet Accountability Foundation, to unmute and say, how did you arrive at where you're at, Marty, and how does this differ, and where do you see your work going?
Thank you very much, Robert. I appreciate the opportunity to be part of this call, and I appreciate the ability to talk about where our work came from and where it's going. And I'm also very pleased to hear that you shared your work with the Singapore Commissioner, because we really are thinking very seriously of doing a legitimate interest project in Asia, and it will truly involve parties in Singapore. The Information Accountability Foundation is the incorporation of the Global Accountability Dialogue that was started in 2009 with its first meeting in Ireland. Emmett Butler was at that first meeting representing the ICO. Elizabeth Denham was there representing the Office of the Privacy Commissioner of Canada. And it was that group that developed the essential elements of accountability. And the essential elements of accountability are in many ways the foundation for the risk-based approach to data protection that is part of the GDPR and part of what will be UK law when UK creates its own version of the GDPR. And when one thinks about risk, it's not the way we used to think about risk in industrial settings. Risk is about the risks that you create for others, the risk for other stakeholders involved in that process. And intellectually, when one thinks about risk, one can only think about risk in terms of benefits. So in terms of this whole concept of how you build an accountability approach to legitimate interests, one needs to think about stakeholders and their risks as is required by the law, but also the concept of benefits that come from that. And when one looks at the GDPR, just like the directive before it, talks about risks to fundamental rights and freedoms. And when one thinks about that, one needs to think about the full range of treaties related to fundamental rights and freedoms and understand this concept that there are risks to other fundamental rights other than privacy when one is thinking about the use of data. So when one is trying to understand our approach to legitimate interest, it's important to understand that broader concept of risk, how it applies to people, and this whole concept of balancing the multiple stakeholders involved, including society's stake in this process as well. In 2013, we were asked by a number of companies to think about how one would do an assessment for big data to assure that big data was within bounds. And that means across both legal systems but beyond the concepts of legal to what it means to be an accountable organization. In doing that work, we built on two frames of reference. The first was that innovative processing has to be acceptable to the multiple stakeholders who are involved. So if one is thinking about how you actually make big data legal, one needs to start with this concept of what is in it for others and how does one begin to parse it. The second is additionally a link to European law, and the fact is that there is privacy as a fundamental right and there's data protection as a fundamental right, and when one thinking about data protection, one needs to be thinking in broader terms. As we get into questions of e-privacy, that difference between privacy and data protection will come into play. When one begins to put these two concepts of what's acceptable to individuals and the fact that data protection is a broader right, one begins to consider when is processing responsible, and responsible in the eyes of a reasonable individual, and what are the benefits that come from processing that are compelling to individuals. And this really does link to the way we think about robust uses of information. And the result of that work was something called the Unified Ethical Frame for Big Data Analysis that was first introduced at the 2014 International Conference of Data Protection and Privacy Commissioners. And it was that work that sparked a lot of interest by European data protection authorities. And they wanted to understand how they could apply these concepts and do so with a fashion where they had a sense that organizations would do this process with responsibility and integrity, which led to a second paper, which was enforcing big data assessment processes. And that work was hosted by the Italian Data Protection Commissioner and the Spanish Data Protection Commissioner. So it was truly international in its scope. And we were beginning to think about how you create oversight. We began to look very clearly at the legal basis that would be used for big data. And it became clear that was legitimate interests. So taking from work that was done by the Working Party 29 and the sense of what it meant to think about ethics as linked the concepts of legitimate interest, we began to describe legitimate interest in terms of big data. When we began to look through that, it became clear that the flip was also the case, that the way to best justify the robust use of legitimate interest is by doing ethical assessments that begin to balance out stakeholder interest. And as I mentioned, this work is truly global. We were asked by the Office of the Privacy Commissioner of Canada to put in an application for a grant to look at big data in Canada. And Canadian law is interesting because it's built on two frameworks. One is the concept of individual consent, and the other is accountability. So in Canada, we built out what is like a legitimate interest process based on the concept of applied consent that exists in Canadian law. But to do that, you needed to focus on what would be seen as responsible by a reasonable individual and within a context of that relationship. When we began to do that work in Canada, a number of European regulators, including the Belgian Commissioner, the Italian Commissioner, the Spanish Commissioner, the Irish and the UK Commissioners, all were interested in when we would do this work in Europe. And we began to look for where we might find a sponsor for that work. Didn't actually find a sponsor, so we decided to do it ourselves. We brought together a group of mostly business lawyers from the European Union and worked through them how we would take the documents that we developed in Canada, which is an assessment and a policy paper that justified the assessment, and actually make that something that would link to the general data protection regulation. We finished that work in early summer, and we then took it into a multi-stakeholder process. And that multi-stakeholder process involved discussions with 7 regulators, most of them at a meeting we held in London, but a few where we went off to visit them personally. That was Italy and Hungary, and began to learn from them what we needed to do to create a full package. Now that full package is now available. We've put it out. Unfortunately, our website's not working today, but if you send me an email to mabrams@informationaccountability.org, I will send you that package. But we developed a package that included an explanation of what we were doing, a chart that gives a sense of what the process is, a policy paper that is long and dense and none of your business people would ever want to read, but it creates the justification for the assessment process, and then a paper version of an automated assessment process that has been developed by TrustArc, who work with us on this, and that TrustArc process integrates the concept of legitimate interest in the comprehensive data protection impact assessments. You can do it separately, but it integrates it together. Now that whole package is available, but it is our feeling at the IAF that we're not the developer of tools. That's for organizations like the Data Protection Network. We believe that the guidance on how you apply legitimate interests to complex ecosystems, that guidance is applicable to any assessment process that is done with competency and with integrity. And the last question I was asked to address is, so what's going to happen internationally? There is a session at the International Conference of Data Protection and Privacy Commissioners that's afternoon long that's about what happens when consent is not fully effective as a means of governing data. And this whole question of assessments is going to be part one of the concurrent sessions that will take place on Thursday afternoon at that conference. And it's also going to be a subject for a number of Latin American regulators who are going to talk about how they're going to move beyond consent. And lastly, as I said, our next project will be a legitimate interest project for Asia. With that, let me give it back to Robert.
Thank you very much, Marty. And a couple of things. We've had a number of questions about, are there more slides? In fact, there is only one other slide that you'll see in a minute, and that's just some additional questions. We've also had one or two questions where I think it would probably be useful for maybe Rosemary and Emma to just say, in practice, because we have about 75% of the people on this call are in the UK that want to use legitimate interest. In practice, how does the DPN guidance take you through the thought process? How does it work? And then we can deep dive into some further questions. So, Rosemary.
Well, I think one of the things that the guidance does is to make it very clear that legitimate interests is one of the lawful bases for processing personal data, and it is up to the controller of that data to consider which is the most appropriate lawful basis for a particular processing activity. So it is a choice, and there is no hierarchy of lawful bases. Legitimate interest sits alongside consent and processing in pursuit of a contract in equal parts. So I think, first of all, the consideration is which lawful basis are you going to rely on. We have something of a chart that suggests how you might do that. But I think once you have considered that position and that you do wish to rely on the lawful basis of legitimate interests, that's the point where you really have to become quite active and actively assess that process, that processing, and balance out, do this legitimate interest assessment. I mean, Emma, it's a three-stage test, isn't it?
So from a practical point of view, as a data protection officer who's done this, essentially you're looking at a three-stage process. So the first process is to identify what your legitimate interests are. Do you actually have any legitimate interests? That at this stage you may have several, and the GDPR is actually quite helpful in that it actually calls out a handful that it says could be a legitimate interest. So that kind of does your stage one for you. Otherwise, you're looking to articulate what are my legitimate interests that I'm pursuing here. Once you've identified those, the second stage is necessity test. Is this actually necessary to achieve my aims? Is there a less privacy intrusive way I can achieve my aims? or is this what I'm considering absolutely what I have to do? And then once you get past that, you're then looking at the meat of the assessment, which is what I call the balancing test. So there you're looking at everybody's interests. You're looking at your company interests, the interests you identified in stage 1. You're looking at the individual's interests and their rights, and perhaps even the broader societal interest, depending on what it is you're looking to do. And you're assessing what are the benefits to each of those groups of people in doing what we're doing, but also what are the risks, and what are the risks of not doing the processing, which could be a risk for the company, but it actually could be risk for individuals as well, and our broader society, and particularly when you're looking around things like fraud and fraud prevention. And then you're looking at what are the safeguards we can put in place, what are the mitigating measures in how we go about this processing to reduce any privacy impact, and to perhaps make this more beneficial for individuals. Depending on what you're doing, there may be an opportunity, for example, to hand some data or results of some analytics back to the individual, which could be useful to them. And essentially you're documenting and assessing all these things, and then hopefully coming out at the end with a conclusion one way or another that says, based on the interest, the benefits, the risks, the safeguards and the mitigating measures, we can or we cannot justify using legitimate interest as our lawful grounds for processing in this scenario.
And so I think just to add to that, if we think of two of the key words in GDPR, which is transparency and accountability, something we haven't necessarily done in the past is probably be more transparent about the fact that we may use legitimate interest. And then I think on the accountability front, the whole purpose, much like with Marty's more full-blown DPIA, with our legitimate interests approach, it's having the proof if you ever need to bring it out from the bottom drawer to an individual or a regulator that says, on balance, we see that doing what we did with your data did more good than, if any, harm at all. And that's the whole point, is the GDPR places the obligation on the controller to think for itself and plan for itself and demonstrate the methodology that's applied. I think that's the benefit of this. So in fact, I guess you would use a legitimate interest guidance on multiple occasions.
Yeah, absolutely. And your assessment where you've documented, your thinking is also you being able to provide evidence that you thought this through and you consider different things, and you can, even if things change over time, you're able to justify why you came to the decision you came to. You didn't just rush into it without thinking.
Marty?
I'd like to add, in the work we began back in 2013, published in 2014, and it's continued forward, and we've refined them. We actually came up with 5 values. And why 5 values? Because you have 5 fingers on your hand, and it makes it useful to do things in 5s. And those 5 values are, is the use of information beneficial? And that's where you balance the benefits against the risks. Is it progressive, necessary, and proportional? In other words, is the risks proportional to the benefits? Are the risks proportional to the parties involved? Is this something that you could do using less data or not? And that's where the concept of necessary and progressive comes in. Is it sustainable? Is this something, particularly when you're doing things that include inferences, are those inferences you understand, and the length of time that you might be able to apply them? The fourth, is this respectful of the obligations that are associated with data? So if there are absolute prohibitions on using the data, for example, to come up with new inferences, then you need to be respectful. And then the last is the question of fairness, where it all comes together. Within the reasonable expectations of individuals, would this processing be considered appropriate based on the context of the relationship?
Thank you, Marty. I want to turn to the questions that you can see on this particular slide, and indeed several of them at the top are very focused on what marketeers want to try and find the ultimate solution for, which is, can we avoid this opt-in thing? Can we carry on doing list broking? Can we carry on doing prospecting without opt in without consent or permission? And is LI the route to go? Well, we know that, as Emma referred to, one of the opportunities under GDPR is you can use legitimate interest for certain direct marketing. So how would you approach that as a marketer, Rosemary?
Well, I'd approach it carefully. I do think that there perhaps is a little bit too much enthusiasm in the marketing community to embrace legitimate interests for all channels and all uses of data. Really need to stress very strongly that, of course, the GDPR is not the only game in town when it comes to marketing. We have the current privacy and electronic communications regulations based on the e-privacy directive, and we are experiencing at the moment a revision of that directive that is happening in Europe as we speak into an e-privacy regulation. So we are subject to two different regimes, two different pieces of legislation. So if you say to me, can I use legitimate interest for all my direct marketing, it says in recital 47 that direct marketing may be a legitimate interest. I will say to you, you can only do that if you can also meet the requirements of PECA, at least for now, and then subsequently the requirements of the e-privacy regulation. So I think we need to be very careful about embracing legitimate interests for all channels. Obviously, some channels, the non-electronic channels, particularly postal channel, it is possible there to use legitimate interests subject to this test, certainly for customer communications, and it's my contention for some prospecting, particularly where the expectations of the individual have been managed as to who their data will be shared with, and specific brands, particularly in those circumstances. So I think we need to be careful. I think the postal channel potentially is one that can benefit from legitimate interests, but we always have to remember we've got PECA on top of that and e-privacy on top of that. And there is, at the moment at least, no concept of legitimate interests in the e-privacy regulation as it is currently drafted, or indeed in the PECA regulations.
Okay, do you want to add anything, Emma?
I would just say that I think it's worth remembering that GDPR and the current data protection legislation is almost like the bottom layer. It's the general framework on fair and responsible data handling. The e-privacy stuff is an additional specialist layer on top relating to a much narrower field, and in this case, electronic marketing. So you're always starting with the bottom layer. You're starting with the, let's say, GDPR for the sake of argument. Can you meet a condition for processing under GDPR? If you decide that you're going with legitimate interest, then you do the test as we've described. And if you come out the other end with a yes, I can use legitimate interest, then you go and look at the e-privacy legislation and see, is there anything else, because it's electronic marketing, that I also now need to satisfy? And if you approach it in that order, then you're probably not going to go too far wrong. If you sort of conflate the two and think that using legitimate interest is your way to do marketing, then I'm not sure that's the most sensible road to go down.
But if you look at, say, some general business requirements like, and you mentioned, Emma, fraud prevention earlier, we had one question about there, you know, if we're using cookies, to what extent can we rely on legitimate interest for further tracking? I see there, can LI be used for corporate governance? Do you think it's fair to say that actually that would be a classic example of applying a legitimate interest assessment and saying for societal good or for other legal requirements or the benefit of the business, if we can show the rights of the individual aren't outweighed, that's our justification for doing it? I
think fraud prevention is one of the easier examples, to be honest, because it's in everyone's interest to prevent and detect fraud. And I think where you're not in an industry that is specifically regulated, that some industries are, have a legal obligation to do certain anti-fraud and anti-money laundering checks and those kind of things. If you're not under regulation, then you don't really have any other lawful grounds for processing. If you look at the list, it's not necessary usually. In some cases, it's not necessary for the performance of a contract. In some, it actually might be. So I use the example of insurance, for example. As part of providing an insurance quote or administering an insurance policy, an integral part of that business is doing some kind of fraud prevention checks, particularly because fraud in insurance is huge. Whereas there may be other industries where they can't justify it under performance of a contract, but it's clearly a legitimate business interest to do some kind of fraud prevention and detection in the background. So I think for a lot of companies, it will be the only lawful grounds for processing, and I think it will be relatively straightforward to satisfy the three-stage test on the basis, assuming that you are doing it properly and responsibly, and you're able to put in transparency and safeguards and mitigating measures, and you're not just sort of going all gung-ho about it. So I think fraud prevention, it's pretty much your only option for a lot of companies.
Yeah, and my contention is actually I think there are other, to answer one question we have up there around corporate governance in general, there is a whole appropriate business that does business intelligence in order to establish in doing a job application or checking out the credibility of a distributor, are these people that we should be doing business with? And I think that's a legitimate interest of the business to engage somebody to carry out background checks. I still think that you would need to have been through a thought process and work out how long do you retain the data and what happens if an individual exercises their rights to know what you're doing about them. I think you've still got to go through that.
Yeah.
There's a specific one that I'm going to throw at Marty, which is around, because this is very much what is driving the IAF approach, is how do you think legitimate interest is demonstratable and usable for things like artificial intelligence, big data, marketing automation, Marty?
So in terms of big data, traditional analytics, you can break analytics into two phases. One is a discovery phase, and the other is an application phase where you take the insights and move them forward. The fact is that this whole approach to legitimate interest was adopted for advanced analytics and has been very compelling to regulators based on this concept that there is a two-step approach, that you come up with an inference and you apply the inference. Of course, you have to make sure that what you're doing is appropriate, and we've come up with a proxy for that in terms of the concept of, is it legal, fair, and just? When you get into the world of artificial intelligence, you have a much larger burden, and the problem with artificial intelligence is that you've lost that middle step where you have thought with data, you consider whether it's appropriate to use it to apply to individuals, and you lose that step. So you lose the human intervention. So what we've been talking about, and we're releasing a paper on or about September 20th, which will also be discussed at the International Conference of Data Protection and Privacy Commissioners, on this whole concept of how you apply ethics and the concepts of legitimate interest to the world of artificial intelligence. And what we are beginning to talk about is that you need to be very public about what your core values are as it relates to artificial intelligence, how you cascade those values through the organization, and then how you can describe them in the outside world. And that then leads to the fact that your ethical objectives are built in with the business objectives when you design the systems that are going to deliver on machine learning or artificial intelligence. We have prepared a worksheet on how you do that. That will be released as part of the paper on September 20th, and it breaks it down to the whole question of ethics, to how you speak about them in business, all the way to how you actually begin to cascade this into computer code. So that will be released on the 20th of September. And I will say this, that this whole question of what is artificial intelligence, how do you apply it, where are we in the development of artificial intelligence is really important to the regulators. They're seeing that these topics go beyond the way the laws are explicitly articulated, so then you have to go into what is implicit in the laws that you can then apply to these technologies.
Thank you, Marty. Looking again at the slide, there's one or two of the bullet points towards the bottom that I think we could also lump together, and I'm going to put these to Rosemary and then ask Emma to comment. But I do know we have a vast number of charities and organized not-for-profit organization and membership organizations, and I think they're all facing the same thing, which is data is an oil of our business. We have to acquire it. We need to do things with it. Consent always seems to be like a barrier. So how do we use this LI thing? And so there's several there. There's a membership scheme that offers enhanced benefits in return for the subscription help with LI. Thoughts, Rosemary?
Well, certainly a membership scheme that has benefits. You put those benefits, if you like, on one side of the seesaw. That is the individual side versus the organisation side, and that would help balance out the organisation's requirement to continue to process that data under legitimate interest. So I think that certainly is something that you would take into account. What benefit to the individual does this processing give? So again, I keep coming back to this though. It depends how this membership scheme is going to be communicated, how it's going to be administered. If you are going down the line of electronic communications to administer your scheme, unless you can argue that those communications are service communications in pursuit of the scheme, if they are in any way asking for money or promoting goods and services, they are promotional communications. That means they get caught. If they are in the consumer space, they get caught by the Privacy and Electronic Communications regs. So yes, it might help you if you want to communicate by post. Yes, I think a lot of charities are addressing legitimate interests and hoping that it is going to help their communications. Luckily, quite a lot of them do use the postal channel quite significantly for their communications. So, and I think they're going to find that it's easier to use legitimate interests for that channel. The actual question we have there is if an individual pledges to a charity and then fails to pay, does legitimate interest allow follow-up? Well, that pledge is a contract, and I would say look at the other lawful bases, and the other lawful basis says that you may process personal data in pursuit of a contract. So I think don't really regard legitimate interest as covering all the processing that you're doing, or try and make it cover all the processing you're doing. Try and make sure that you are precise in the processing that you're trying to cover with these tests.
Okay.
Yeah, I would agree with that, and I think in terms of the membership one, like everything in data protection, the context is important. Say you offer a membership scheme that has 3 different levels, for example, a basic, a advanced, and a super, or whatever it is, and they each have different benefits and so on, and they rely on perhaps more data the more up the chain you go. Well, again, that's a straightforward scenario where the individual is making a choice as to which level of membership they want, and to administer that level of membership, you need X amount of data, and that's all very clear and transparent. I would argue you're looking at performance of a contract. You're not even going anywhere near legitimate interest there. So I think context and it is very important. What is it that you're trying to do, and how are you setting it up, and actually is legitimate interest the right one? And I would say don't forget about performance of a contract. And in my experience, most business processing in the private sector is generally performance of a contract, legitimate interest, or legal obligation. Generally speaking, most of your processing falls into those three categories. So I would look across the board to decide on the right one.
I'm actually going to move on to the other questions, because you just mentioned, Emma, private businesses. And Rosemary, I'm just going to throw this one at you. Do you think that public authorities have a right to use legitimate interest? Because on a first reading, the answer would appear to be no.
It would, because there is a prohibition in Article 6.1 that says that public authorities may not use legitimate interests in performance of their tasks. So I suppose the first question is, would they ever be processing data that wasn't in performance of their tasks? And of course, they also may rely on legal obligation or public task as an alternative basis. Here we go again, choosing the right one. But we did get some intimation when we were putting our guidance together. We got some intimation from the Information Commissioner's Office that they considered there may be some circumstances where public authorities might be able to use legitimate interests. It also might, I think, depend on the definition of a public authority that we get in the Data Protection Bill. So certain organisations that might be subject to freedom of information and therefore public authorities under that statute question whether they will be regarded as public authorities. I mean, one would imagine it'd be an awful lot easier if it were the same. But,
Marty, yes.
So the fact is that when you get into the discipline of balancing stakeholder interests, while it's necessary for legitimate interests, it's actually useful for other legal bases other than consent. When you've gone through this process of understanding what the stakeholder issues are, you can actually see whether you can justify the other legal basis based on the reasonableness based on the context of the use. So the fact is that once you get into this habit of actually understanding stakeholder issues and beginning to resolve them, then you actually find that the balancing of interests process is useful for those other legal bases to process, particularly in the public sector domain.
I think you mentioned, didn't you, Marty, earlier, you mentioned this, the concept of reasonable expectation, and I think that's something that we haven't touched on significantly here, but it is, of course, quite a difficult thing to pin down. What would my reasonable expectations be in circumstances? Would it be within my reasonable expectations that a public authority would process my data if I fall within their remit? My answer to that would be yes, I believe it would. Would it be within my reasonable expectations that a charity would process my data and communicate with me if I'd made a donation? Again, my answer to that probably would be yes, it would. And I think one area we haven't touched on at all is business to business.
Yeah, okay.
And of course, the complications are slightly less there as far as UK law is concerned, because our PECA regulations hardly touch business to business, corporate business to business, as so they don't have the same impact as they might on consumer marketing by e-channel. So just on that point, I think that in business to business there may well be more scope possibly to argue that legitimate interests may be used for processing of business contact data, just to put that one to rest.
But obviously what happens in a lot of things that happen in B2B, I've had 2 or 3 questions that have come in that are particularly on things like executive search, or indeed going out and screen scraping information. To what extent is that a reasonable, legitimate interest of the business to use publicly available sites, etc., to build up information on targets for recruitment? What do you think, Rosemary?
I think I would be a little careful here again. That the suggestion that if I put my data in the public domain, it's fair game. I think is a dangerous one. Although it is not sensitive data, potentially you could argue the fact that I'm a director of a company or whatever is much less sensitive than information about me as an individual. But I would be aware also that, of course, the sites from which you potentially might be scraping this data might regard what they have published as their copyright, and therefore you may well be breaching their terms and conditions by so doing. Certainly, use for sort of multiple reuse. So you scrape the data and then you sell it on to half a dozen executive search companies. I don't believe would be appropriate. I don't know about you.
No, I would agree. I was going to make the similar point that you know, you still have to handle data, personal data, fairly and responsibly, even if it's in the public domain. So again, context is important. Are you sourcing business contact details from kind of a business website as opposed to a, you know, an informal chat room forum where somebody happens to have used their work email, for example? Are you complying with the conditions of the site with regard to copyright and scraping? A lot of common sites do actually prohibit that in their terms of use, that you're not allowed to scrape it. So you've got to look at all that. And yes, generally business contact details are not as sort of sensitive, and processing them isn't as intrusive. But you're still, you know, it's not a free-for-all. You're still looking at fair and responsible data handling, and you know, in the same way you would with other data.
Marty.
So the concept of the value that we talked about just a few minutes ago, of you need to be respectful of the obligations that come with data. When you're screen scraping, that's really where that principle comes into to play, because you have to be respectful for the context in which that data appears at that website and the conditions that website has set for it. So I think one would have to be very cautious and go through an analysis that says, yes, that use is indeed respectful of the obligations with that data.
And I guess what has been a sort of constant theme in the background of what we're discussing is that GDPR is not necessarily prescriptive, and it is placing the responsibility or the obligation on the controller to give some thought and to start on the basis ethically of just because we can doesn't mean we should, and that might apply to a whole host of different processing activities. Equally, because I think we're not getting the guidance that everybody wants, the definitive guidance. The only way to have a defense is to at least show a regulator, or indeed an aggrieved data subject, here is why, in all the circumstances, we still felt that this was a not unreasonable approach. We took your data because it's available on public sites, but hey, look, you've got the opportunity of you've been you've got a job application. Yeah. You wouldn't have had that if we didn't do this. I think we should also say the challenge of legitimate interest is that everything in GDPR points to there being some existing relationship, and that does make it a challenge when you're completely cold calling or cold approaching. But one of the other questions that we had on the previous slide, which I think, to be fair to some of the other questions we're getting in, what do we mean by a third party? Because legitimate interest benefits the controller or a third party. Rosemary, what do we mean by a third party?
We mean a separate controller of data, an organisation separate from the original recipient of the data. And I think that can include, of course, other group companies, which I think is something that one of the areas where this suggestion that legitimate interest can extend to third parties will be useful, because third parties sharing with third parties in the same group, again, so long as the expectations of the individual have been managed by making it clear to them at the point the data was collected that their data may well be shared with other organisations in the group under legitimate interest. So there's this requirement to tell, this requirement for transparency is, if you like, another check on the whole idea of legitimate interest being a free-for-all and a get-out-of-jail-free card.
I think actually that's a really good point. I think a good question companies should often ask themselves is, are you in any way nervous or uncomfortable about the transparency? Are you nervous about telling people what you're doing? And if the answer is yes, we'd rather not tell them, then I think that's a big red flag to
Yes.
question what you're doing in the first place.
Yes. So, question up here, that I'll start again with you, Emma, and then I'll get Marty to jump in. How do you communicate your reliance on legitimate interest to customers, and how much information do you have to give them, or is this just an internal document?
Well, under GDPR, as you know, we do have to say now at some point, I would imagine most companies will do it in their kitchen sink privacy notice, that what your legal basis, lawful basis you're relying on, and if it's legitimate interest, what those interests are. And I think most companies are sort of scratching their heads and going, well, how are we going to do that? And I haven't seen any kind of front runners putting their head above the parapet and going, okay, we've decided we're doing this. I think we're all kind of figuring it out, and it's perhaps a bit early to be committing to a brand new privacy notice that's GDPR compliant. So I think we'll maybe start to see more of that beginning of next year. I think for me at Yoti, one of the challenges we have is that our product is an app. And an app is a mobile phone, is a very small screen. And so we're very much looking at the moment at the challenge of how do we do user-centric transparency? How do we get the right information to individuals at the right time, but provide further detail for those who want it? So we're very much looking at having what I call the kitchen sink privacy notice, which will always be there somewhere, which will have, you know, everything in it. And ultimately, the audience for that is most likely to be, let's be honest, regulators and activists. But actually, the user using the app is not going to want to read through all that. A lot of it they won't be interested in. So how do we get them, as they go through the app and the different stages of using it in their journey, the right information, and put links in if they want to dig deeper? And that's our approach. So we haven't made any decisions yet, but my kind of best guess at this stage is that we'll probably deal with lawful grounds for processing and legitimate interest in the kitchen sink privacy notice. I can't see at the moment an obvious logical place to put that in the app. Yeah. And I think we'll probably be looking to describe things quite broadly in a way that makes sense to users, because I think if you're too vague, people don't really know what you're doing. But if you're too specific, you need 40 pages, and people, you know, just don't want that level of detail. So where you are relying on legitimate interest, it's just about, you know, explaining. I always take the approach: how would I explain this to my mum or my grandma in a sort of easy to understand way? Why is it that we're doing what we're doing, and how is that of use to you? How does that benefit you? I think stressing those benefits will become more crucial, because individuals are more likely to be happy with what you're doing if they can understand why, and why it might be useful for them, what they're getting out of it. Marty?
So if one goes back to the essential elements of accountability and how they were developed in 2009, one of those essential elements is transparency. And transparency is much more complicated as the processing gets much more complicated. So think of a mental health app that it is suggested that you use because you have mental health issues, and think about the complexity of trying to explain that in the small screen that Emma described. It's just damn near impossible. So the concept is that there is a very detailed privacy notice. It is available, but it is really targeted at the regulators. So when the regulators say, can you describe your use of information, you have it there, and then you have to figure out the multiple ways in which you communicate to others based on your context, the relationship with that. And the whole concept of you thinking about where data protection will be in 2022, which is only 5 years away from now, I think this concept of trying to separate the informing of individuals and the legal notice that describes your use of information increasingly are going to move apart. But going back to Emma's point on a previous one, if you're afraid to talk about what you do with data, then obviously you shouldn't be using the data to do it. So the fact is that organizations are going to increasingly be expected to be able to describe in understandable terms, in bite-sized pieces, what they do with data. And the more complex your processing, the more important being able to be transparent will be going forward for trust reasons as well as legal reasons.
Thank you, Marty. We're getting towards the allotted time. There's a comment or a question just come in which links to the penultimate bullet point there. What if, having said we think it's legitimate, we get an individual who says, well, I challenge that? How do you track the basis on which you relied for a particular set of personal data, and how would you respond to an individual exercising their rights when, if you look at GDPR, not all of the rights of a data subject apply to legitimate interest, that apply to contract and consent? So we know that some advantages, in inverted commas, of legitimate interest are that certain things like right to be forgotten or data portability don't necessarily apply to those. So it's more, I think, a technical answer. But how, Rosemary, do you anticipate, particularly, let's say, the marketing companies are going to construct the segregated types of permission data that they've got?
Well, there are a lot of organisations mulling over that as we speak, in fact working on it in terms of how much more they now have to record from an accountability point of view on their database, exactly what they're relying on. Have they got consent? If so, when was it given? What does it look like? If they haven't and they're relying on legitimate interest, have they done their balancing test? Have they notified individuals properly? And have they got a mechanism whereby an individual can put up a hand and say, I do not want my data processed under legitimate interest? I think there's two things there. There's the individual's right to object to processing under legitimate interest. That, I would say, if an individual or a number of individuals object, doesn't necessarily mean your balancing test has flown out the window. I think if an individual is challenging the legitimate purposes and the fairness of it and the transparency of it, that's a different question.
Yeah, I don't have the detail of the rights in front of me, but yeah, if somebody objects on that basis, then from memory that does apply if you use legitimate interest. Then I think most companies will go through a normal complaints process where they will sort of explain their position, assuming that they still think it's a defensible position they can stand behind. They will explain why they think it's legitimate to be doing what they're doing and why that means, for example, they can't delete the data or whatever it is the individual has requested. And ultimately, if the individual's not happy, they're going to go to the regulator. And that's where we're going to see the test cases develop, where the ICO, in our case in the UK, gets involved and makes a decision one way or another. And I think where a company has done it properly, they've thought it through, they've documented it, and they feel they can stand behind their decision, the mere fact that the regulator says, well, actually, we don't agree, we would have come to a different decision, yes, that will have an impact on the company, but I don't think the ICO is going to start penalising companies too harshly because they've shown they're working out, they've shown they've thought it through. It just happened that the regulator said, well, actually, we would have concluded differently. And then, yes, it may stop some processing or whatever you're doing, but I don't think companies should be afraid of sort of, 4% of turnover fines for something like that. But ultimately, we may end up with the regulator determining where the lines in the sand are in due course.
Marty, any final comments from you?
That is actually an incredibly important question because I spend a great deal of time with regulators all over the world. And the biggest question that they come is, okay, an organization is doing an assessment. How do I trust that assessment? So from a principles perspective, organizations have to stand ready to demonstrate what they did and why they did it, and to show the regulator that they did it with competency. In other words, they have the skill set to do an assessment, and they've done so in integrity. In other words, they have not gamed the system or gamed the assessment so they win. And I think that second part is a very important question. And I can tell you that in having worked with Elizabeth Denham for years and years and years, that concept of competency and integrity is very important to her.
Thank you, Marty. We've gone over just by a few minutes the allotted time, and I have got a heap of questions that have come in from you as we've been talking, and I apologize if we've not specifically answered them, although I think generically we've gone through a fair amount. And it seems to me we have got to be more transparent in the language we use and the way we communicate. Picking up on Emma's point about let's not forget other lawful grounds, I think for a lot of you who engage with either business or consumers with some contractual terms, the more you can say in the contract are the values that you offer as part of the membership scheme or the insurance, and what are the consequences of somebody engaging with you for a quotation or actually as an insured or whatever. I think the more you can show the regulator we were being as transparent as possible, and in the background we were doing an analysis of whether we should and whether we could and how we would, the better. Just as I close, to let people know, in terms of what Marty said was available documentation, and indeed what Rosemary has said the DPN have got, various people have said, where can we download, etc. If you would like to email in to us at Bristows, we can forward you the links to the available documentation. We do know that there's a lot of people said they'd like to work on version 2, please, by having responded to our question, I trust that we can use our legitimate interest to come back to you and let you know when we might be having, for those of you in the UK at any rate, another sort of larger meeting to talk through how we could move to version 2. I know that the ICO is looking at guidance for things like legitimate interest, but since we don't have consent, I'm not sure when we'll get LI. But as I said, she does find, from a UK perspective, what we are doing is appropriate. So I would take away the good comments made by our 3 speakers in terms of thinking about the right approach to this, being able to argue your corner. If somebody says, why did you think that was a legitimate interest? It is not a quick tick box exercise. It needs considerably more than that. But then that's what GDPR is all about, is doing privacy impact assessments and so on. We hope you've enjoyed it. From me to Marty on the line, and to Emma and Rosemary sitting in front of me around the table, thank you very much on your behalf. We will be publishing details of our next webinar as soon as we have got our act together, so to speak, and we look forward to being with you on another occasion. Thank you. Bye-bye.